Good afternoon. Welcome and thank you for joining us for this conversation on pocketbook justice. Over the next hour, we're going to be looking at the financial conditions and the penalties of bail, fines, and fees, looking at their significance within the system, the role they play toward or away from just and appropriate outcomes, and the impact on the lives of the directly affected individuals that come into contact with the system. I'm Cook-McCormac. I manage political, philanthropic, and public policy efforts for Margaret and Daniel Loeb. Margaret and Dan are deeply committed to the issue of criminal justice reform and have made it a core part of their philanthropy, which has given me the opportunity to work with many of you in this room, many of the organizations and speakers that are involved in today's summit. And thanks very much to Aleph for putting this conversation together. I first had my eyes open to these issues when we learned about the story of a man in New Mexico named Tom Chudzinski. And Tom was 62 years old. He was suspected by the police of drunken driving. They knocked on his door late at night of his motor home, and they arrested him. He could not make bail. $50 bail he was unable to make. He was estranged from his family, did not have access to any of the capital. He spent 34 days in jail. During that time, all of his possessions and his motorhome were impounded. They were ruined over the 34 days and was not able to get access to it until many months later when he discovered that all of his belongings had been ruined. And he ended up in a homeless shelter. And it took him several months before he was able to get the bus fare and those things together to start to get his life restarted in Los Angeles, California. And so that's just one of the many stories of how these financial conditions can really impact people in the system. So needless to say, these issues really matter, and we have a great panel here today to discuss them. The first is Matt Alsdorf. Matt is among the nation's top experts and thought leaders on bail reform. He's the president of Pretrial Advisors, where he advises governments and philanthropists on criminal justice. He previously was a journalist, federal law clerk, practicing attorney, and vice president of criminal justice for the Laura and John Arnold Foundation. Also with us today, Joanna Weiss. Joanna, similarly, is among the foremost experts and thought leaders in her field, this of fines and fees in particular. She's the co-founder and co-director of the Fines and Fees Justice Center, where she leads efforts to elevate and advance these issues. And also, like Matt, she's an alum of the Laura and John Arnold Foundation, where she served as Director of Criminal Justice. She also previously served as an attorney and an official for the City of New York. And then last but not least, we have a practitioner, Zach Klein, with us, who's a thoughtful prosecutor who's focused on just outcomes as a part of his job as Columbus City Attorney, which he was elevated to January of 2018. He's got a pretty wide resume. Previously a councilman, president of the city council, an attorney, a law clerk, a White House official, an assistant attorney general for the state of Ohio, and a special assistant U.S. attorney. So let's get started. And we will leave time for questions toward the end of the presentation and conversation. Today we want to do two big things in particular with the scheduled panel. First of all, to really frame the situation, why these issues matter, what the lay of the land is across the country, and also to talk about solutions going forward and a path forward on these issues. So without further ado, I'll turn it over to Matt to get us started. Matt.
Thank you. Good afternoon, everyone. Thank you for having me here. So I want to start out by talking a little bit about why we care about bail reform. And I was turned on to this quote by Dr. Marie Van Nostrand, who you'll hear from tomorrow, a colleague and friend of mine, when we started on this work. And the quote is from Professor and activist Caleb Foote, that pretrial decisions determine mostly everything. And we mean a couple things by that. On the individual case, the decisions that are made early on in the process determine everything that follows, as we'll see during this presentation. But it's also true on a macro level right now. This is a hard graph to read, but essentially it shows the growth in jail population between the boxed area is 99 to 2014. And during that period, 99% of the growth in the jail population in the U.S. was from pretrial detainees. That is, people who've been accused of crimes but not yet convicted. So essentially, all of the growth in the jail population came from the pretrial population. So if we care about who's in jail, we care about these bail decisions. And I call this the $14 billion question because that's about how much we spend every year incarcerating people pre-trial. So are we detaining the right people? And this slide I worked on for a long time. The answer is no. And I joke about that, but it is really a very straightforward no. There's basically no ambiguity here. And I'll go through some of the issues quickly, and we can delve into them a little more during the discussion. But essentially, if you look at any jail population right now in the United States, you're not going to be happy with what you see for two reasons. You're going to see a lot of people who are behind bars, who haven't committed any particularly serious crimes, who do not appear to pose very significant risks to public safety or of flight, and yet they're in jail for long periods, often because they can't afford modest amounts of bail. There are a couple examples up here from a few jail population studies nationally. We don't have great national jail data, but every jail population study that's done tends to uncover this sort of thing about low-risk people stuck in jail because they can't afford bail. And there's a lot of research, a growing body of research that really shows the detrimental impacts that needless pretrial incarceration can have on a person. Loss of job, destabilization of housing, undermining family ties, loss of educational opportunities, etc. And of course, it also makes it really difficult to prepare your defense if you're behind the bars. And this will shock no one here, pretrial detention rates are not equal across racial groups. People of color, especially African Americans, especially African American men, are detained at rates that are much, much higher than white people, even when charged with similar crimes. And interestingly, even though we're wildly over-incarcerating people, we don't do a great job protecting the public. And again, because the jail data nationally is a little bit spotty, there isn't sort of a national stat I can cite on this. But when I was at the foundation, we did some research looking at one large jurisdiction and found that 50% of the top 1% most dangerous defendants were getting out before trial. So lots of people who would be considered high risk and dangerous are actually able to buy their way out. So here's what I want to focus on. I think this is really important. If what I'm saying is true, and you'll have to go with me here, that we are detaining the wrong people, why is that happening? And I think there's something fundamental going on here. And that is that we're asking the wrong questions. We're asking judges to answer the wrong question. So forget everything you know about bail. What would the right question be? When someone comes into court after having been arrested at night, they come into court in the morning, what question do we want the judge to be answering? Well, in my view, the right question for the judge to answer is, should this defendant be detained? So, jail versus going home. Should this defendant be detained? And we could talk a lot about, what criteria you use to make that decision, but fundamentally, a judge needs to be making a call about whether somebody might skip town or might commit a new crime and therefore needs to be detained as opposed to returning home. But weirdly, that's not the question that we have judges answer. In most situations, in most jurisdictions, the question judges answer is, how much money should somebody pay to get out of jail? And so instead of jail versus home, it's a low amount of jail, a low amount of money bail versus a medium amount or a high amount. And I want to propose to you that this is lunacy. And the reason it's lunacy is that it results in completely counterproductive and wrong decisions. And you're probably familiar with at least one of the two cases here. Khalif Browder, who was arrested here in New York for allegedly stealing a backpack. His bail was set at $3,000. He wasn't able to make that amount. He spent 3 years on Rikers Island because he didn't have $3,000 and because he had allegedly stolen a backpack. As many of you know, tragically, he killed himself a couple years after he was finally released from jail. On the right is Robert Durst, who was the subject of a pretty compelling HBO documentary called The Jinx. He was accused of murdering his wife in the early 1980s on Long Island. He was never actually convicted or charged with that crime because they couldn't find the body. But then he went down to Texas and he was arrested about 20 years later for killing and dismembering his neighbor. He was arrested, and the judge said, wow, you have a kind of bad track record. This is pretty serious. Your bail's $300,000. Well, turns out Robert Durst is a Manhattan real estate heir, and so he posted bond the next day, skipped town, and went on the lam. And what I think is so sort of crystallizing about this case is it's not that the judges in these cases got it wrong. It's not that they said Khalif Browder's dangerous and Robert Durst isn't. It's not that they made the wrong decision about who should be detained. It's that they set money bail on both of them, and it turned out Khalif Browder was poor, and it turned out that Robert Durst was rich. So when we have a system that doesn't ask fundamentally the right question, we end up with results like this, and these are sort of extreme cases, but they're happening every day in this country. So quickly, what would a better system look like? I think there are four main criteria. There need to be clear and limited criteria for detention. As I'll talk about in a second, this will probably require legislative change in many jurisdictions. So not everyone is eligible to be detained pre-trial. Second, judges, not money, need to actually make that decision about who's detained and who's released. Defendants, before you get detained, because you are presumed innocent and freedom, physical freedom is the most foundational type of liberty, you need to have strong procedural safeguards before someone can actually be detained. And conditions of release should be set according to the risk principle, which essentially means if somebody is low risk, they are just released with no conditions or minimal conditions. And if we're going to restrict people's liberty, either by detaining them or by putting an ankle monitor on them or making them check in with a pretrial services officer, we have to do that only because they pose significant risks that those conditions would mitigate. And I'm trying to do this briefly to leave some time for questions, but there is a lot of movement and a lot of energy nationally to change the bail system in ways that I think we all would agree are positive. And really there are three main vectors for that type of change: litigation, legislation, and then local change at the policy change at the local level. Quickly, nationally, there's been a raft of cases using plaintiffs like Khalif Browder, usually people who are not dangerous but are in jail because they're poor. Those decisions are complicated and sort of multifaceted, but there are clear trend lines, which is that courts are moving to reduce reliance on money bail generally. They are eliminating the use of bail schedules, which basically say if you're charged with X crime, here's how much you're going to pay regardless of any other factors and regardless how much money you have. Increased individualization so that people actually have some procedural safeguards and hearings. And essentially the bottom line of these decisions, which are not national yet, but they're working their way up the court system, is that there's less money, less detention, and more procedural protection. Legislatively, there are a lot of changes, and this gets very complicated. So again, I'll say this quickly, but the big changes in legislation have to do with defining who can actually directly be detained, not who accidentally ends up in jail because they're poor, but how do we define the pool of people who we say, you know what, there are reasons that we don't want to release you before trial. How do we define that group? And then other legislative reforms are related to getting more people out, using risk assessment, various types of risk assessment to help inform those decisions, and disfavoring, again, the use of money. And final point I want to make is just that a lot of the good news is, legislation and litigation are tough. They're hard to get done. Litigation's adversarial. But the good news is that a lot of these changes can be done by local policymakers, which we will hear later from our Columbus DA friend, because there's a lot of power that local decision makers have, not just courts, but prosecutors and other decision makers in the system, to stop doing things the way they always have done them. And I will stop here. I can talk a little bit more detail when we get into the discussion about some of those local policy changes, but I don't want you to leave thinking the only way to change this is to bring a case or change the laws legislatively. Those are important vectors, but there's a lot that can be done at the county and local level. Thank you.
Thanks, Matt. And we will definitely have time for questions at the end here. Joanna, fines and fees.
So we're going to continue to talk about criminalization of poverty, but we're going to move away from the front end of the system and move more towards the back end of the system. And I'd like to start this conversation talking about Ferguson, Missouri, because for many of us, this was the awakening about the crisis of fines and fees around the country. In 2014, as all of you know, a young black man named Michael Brown was shot by police, and the city really erupted in protests. Night after night, people came to the street, demonstrating a tremendous amount of pain. And what was palpable was not just a distrust of the police, but a distrust of the entire justice system. And so after the protests came to an end, the Department of Justice's Civil Rights Division went in to investigate the Ferguson Police Department, and that was their mandate, to look at what was happening with the Ferguson Police Department. But when they got there, they realized that the Ferguson Police Department, City Hall of Ferguson, and the police department were really, and the court system were inextricably linked. Because when the city needed money, the police were told to write more tickets. And at the time of the investigation, what they found was that Ferguson was deriving more than 20% of the revenue for the entire city through fines and fees. And then the courts would be the ones who heard these tickets. And if you couldn't afford to pay, or you missed a court hearing date, there was a warrant issued for your arrest. And at the time of the investigation, Ferguson, Missouri had 21,000 people. They had 32,000 open bench warrants. Almost all for unpaid fines and fees or missing a court hearing on a low-level violation. The other thing that I think is important before we also get too far into it is to talk a little bit about what I mean by fines and fees, because I think people use these in different ways, but I think we all know what fines are if you've had a speeding ticket or a parking ticket. It is a monetary sanction. It is meant to be punitive. The origin of this was really as a substitution for incarceration. We could fine people as a punishment instead. Now, of course, we use fines not just for low-level violations where incarceration would probably be inappropriate, but also for misdemeanors and felonies where we also may incarcerate someone and we may impose a fine on top of that. So, for example, in Florida, felony drug trafficking is defined by the quantity of drugs you have. And 7 grams of oxycodone or 11 Percocet is considered felony drug trafficking. And in addition to whatever jail time you get for that, you will get a $50,000 fine. Fees are what I bucket together all of costs, assessments, surcharges, anything that is basically a user fee for touching the criminal justice system. As the criminal justice system has grown over 40 years, it's gotten very expensive to incarcerate this many people. I mean, we know that we have, at any one time, 2 million and change people who are incarcerated, but over a year, we have more than 12 million people passing through our jails and prisons. And this is expensive, and so jurisdictions have come up with a way of trying to defray those costs by charging the system back to people going through it. So depending on where you live, you can be charged prosecution fees, booking fees. In most states, thankfully not New York, you can be charged a fee for your public defender. In some places, you are charged even for applying for a public defender, dissuading some people from using one. There are all sorts of ways that these can accumulate. So by the time you finish your touching of the criminal justice system, you can owe thousands or even tens of thousands of dollars in debt that for people with a criminal record have very little hope of ever paying off. And of course, when you can't afford to pay it off, there are all sorts of adverse consequences that really create 2 tiers of justice. So people who can pay and leave the system and walk away have one form of punishment. But for the people who can't afford to pay, they end up getting further and further entrenched into the system until they have an endless cycle of punishment and also entrenching poverty. So if you can't afford to pay, you can end up with more fines and fees. You can have a prolonged justice involvement. You may not be able to get off probation or parole. You can have a civil judgment against you, which can destroy your credit, which can deny you access to jobs, housing, loan that you need to get a car. Your driver's license can be suspended, and you can even be incarcerated. And one thing we should add to this list is your voting rights can be removed. If any of you have been paying attention to what's been happening in Florida, and Florida is not alone in this, but under Amendment 4, Floridians voted by supermajority to restore the right to vote to people who had been convicted of felonies. And the legislature just decided that if you have not paid off your fines and fees, you have not completed your sentence. And so if you have money, you pay off your sentence and you can vote and your rights are restored. If you do not have money, if you are poor, you can't vote. But in addition to the impacts on individuals, there's also impacts on all of us by this reliance on fines and fees as revenue to support government. There was a study out of Alabama by a group called Alabama Appleseed that surveyed 1,000 people who had criminal justice debt and couldn't afford to pay it off. And 38% of people admitted in the survey that they committed another crime in order to pay off the debt. The other thing, there's a study that came out last year by researchers named Sansis and Yu and Goldstein, who looked at 1,000 cities across the United States of 28,000 people or more. It turns out the average size city in the United States is 28,000. For those of us who live in New York, this is shocking, but it's true. But they looked at 1,000 cities thousands of cities of 28,000 or less, and they found that the average city gets 1% to 2% of its revenue through fines and fees. But for every additional percent of revenue that cities get from fines and fees, that correlated, that was associated with a 6.1% decrease in resolving violent crime. Which of course makes perfect sense, because if our criminal justice system is designed to protect public safety, we need to use it to protect public safety. If we are using our police and our prosecutors and our courts and our jails to raise revenue for the city coffers, we're not going to be addressing crime. We're going to be criminalizing poverty. And I just want to go a little bit into the example of driver's license suspensions, because I think it's a very good way of explaining how fines and fees criminalize poverty. So in 40 states today, a little more than 40 states today, if you do not pay off your fines and fees, your driver's license is suspended. The idea is that this is going to coerce you into paying. But it turns out that when someone's license, having your license suspended doesn't actually magically put money in people's pockets. When you have cities that are relying on fines and fees and issuing more and more tickets, you're going to run into more and more people who can't afford to pay. And obviously, a driver's license in the United States is absolutely critical to access your basic necessities. About 80% of Americans drive to work. For about 30% of people, having a valid driver's license is a requirement for your job. And so most people have no choice but to continue to drive. And the next time they drive, they're pulled over, and now they're charged with driving on a suspended license. Now they have a criminal record, more fines and fees they can't afford, and possible jail time. And just to give you a sense of the proportion of how much this is driving the issue of mass incarceration, driving on a suspended license, and the vast majority of those are for non-payment of a traffic ticket or missing a traffic hearing in New York. In New York City, driving on a suspended license is now the 4th most common criminal charge. In Rochester, New York, it is the most common criminal charge. And if you look around the country in city after city, this is what is sending people into the courts. Now for some good news, really quickly. We think that there's a lot of opportunity for reform because this is an area, one of the few areas where there is tremendous bipartisan support. We have groups as varying as ACLU and Southern Poverty Law Center, with the American Legislative Exchange Council and Right on Crime and the Institute of Justice, which are just not groups that we always talk about together. The other thing is that there are prominent organizations like the ABA that have weighed in on this and really tried to give good advice to court actors and policymakers about how to handle fines and fees better. And ultimately where we should be going is we should be eliminating fees in the justice system. The justice system is meant to support everyone, and it needs to be funded equitably by everyone. And some places are moving in that direction. San Francisco and Alameda counties have stopped the use of discretionary fees. When I say discretionary, those are the fees that the county has the authority to impose, and they have decided that they will no longer do it. In addition, we're seeing movement around the issue of juvenile fees, because we use this in the juvenile justice system as well. California, Orleans Parish, and as of about 2 weeks ago, Nevada, have all stopped using fees in the juvenile justice system. In New York City, and as of last week, San Francisco have stopped charging for phone calls to and from jails. On driver's license, there's also been a tremendous amount of reform. 6 states have stopped suspending, and another couple of states have eliminated the driver's responsibility fees, which are driving a lot of the people going through the justice system. And I just want to highlight that although a lot of the reform has happened through legislation, some of which came because of litigation or threats of litigation, there's also been a really exciting move by prosecutors to get in on this and help with reforms. About half a dozen prosecutors have stopped have stopped prosecuting people for driving on a suspended license. If the underlying suspension is not for dangerous driving, those people probably don't need to be in the justice system. And so some prosecutors have stopped prosecuting entirely. Others are working with courts to help get old cases off the books that have old debt that are never going to be collected. And then if you are looking for other models for reform, I just want to highlight that we have a clearinghouse up on our website where we've collected a lot of the legislation, litigation, pilot projects, research, everything about fines and fees reform, so that if you're looking for different models that exist, it's a place that you can find it.
Great. Thank you, Joanna. So let's hear from one of those prosecutors. Zach, tell us a little bit about why you were inspired to take on this role that you're in now. A little bit about why you think these reforms matter so much, and also a little bit about what you're doing
Sure.
to correct things in Columbus.
Sure, thanks, Jeff. How y'all doing? I'm Zach Klein. I'm the Columbus City Attorney and prosecutor in the city of Columbus in Ohio. We're about 950,000 people. We're the 14th largest city in the United States. A lot of folks believe that Cleveland and Cincinnati, my brethren, sisters, and brothers, are the largest city. We're 3 times larger than both of those cities. So we have a lot of responsibility, yet a lot of opportunity that's going on in the city of Columbus. I'm the elected prosecutor. I think it's me, LA, and Seattle are the 3 largest cities in the United States that have independently elected city attorneys, not exactly prosecutors or DAs, but city attorneys. And my jurisdiction is all misdemeanor crimes that happen within the city limits. And that ranges everything from an open container at an Ohio State football game all the way up to something serious like domestic violence. And so for a lot of the same reasons that I've heard other panelists talk about, the criminal justice system is broken. The war on drugs has been a failure. There's no metric, I think, that we can point to in the United States to show that what we're doing is the right way to handle the criminal justice system. Those are the reasons that I ran for this position. And the reason why I feel like I have tremendous responsibility while driving the keys to the prosecutor's office in the city of Columbus, that I have a responsibility to do my part for major reform. Of course, it's for social justice reasons. The numbers speak for themselves as it relates to primarily and particularly to people of color and their interaction with the criminal justice system. But it's also about community safety. Nothing that we're doing is showing that we're making our community any safer. We've gone through the motions of doing the same thing over and over again, except expecting a different result. And that's been the decades-long approach to the criminal justice system that we need to refigure and rethink in order to make our community safer. But finally, it's also about economic development and economic opportunity, which I don't think we talk enough about in the criminal justice system and the reform movement. And I actually heard a question that was maybe 2 panels ago over in the main room about how do you get people who may not care so much about criminal justice reform, like we care about, to care more. And I think that the economic development and the cost to taxpayers and where that money could be reinvested is an important part of our conversation that we need to talk more about. Not only is it about those afflicted by addiction and those who have mental health problems that are in the criminal justice system that desperately need help to return to be able-bodied moms and dads that they want to be, that they desperately need, but they need help in getting there. But it's also those that have barriers like felony convictions that stand in the way of getting true gainful employment. We have several Fortune 500 companies in the city of Columbus, and I've personally talked to CEOs, and for various reasons, they have told me straight up, we cannot hire felons. Doesn't matter how long ago the record was, doesn't matter if it's nonviolent, we cannot hire felons. So how are we giving folks an opportunity to pull themselves up by the bootstraps if we've taken off their boots? And that's essentially what we've done by handing out too many felony convictions. And that's not to say, when you're talking about this sort of reform and the reform that's necessary, that there aren't bad people that deserve to go to prison or deserve to go to jail. It doesn't mean that we should get rid of felonies altogether. There are rapists and murderers and human traffickers, folks that should be labeled as felons. But we have over-felonized the type of crime that we have then subsequently labeled individuals with. Ohio is probably the second hit state in the opioid crisis. And addiction is not new. It's plagued communities of color in rural, poor America for decades. But now that it's creeped into suburban America, all of a sudden we've had a newfound belief and approach of how important drug addiction policy is. So how do we take this moment of clarity for reform so that we can not build a model for opioids, but build a model for drug addiction and mental health? And I really applaud the work that y'all are doing in the fine, fee, and bail space. Because really this conversation is about the intersection of poverty and the criminal justice system, which plagues and hurts too many people that interact with the system. I think when you take out the folks who are the truly, bad individuals, you're talking about the other, 90% of the folks that are interacting with the criminal justice system because of poverty, because of mental health, because of drug addiction issues. So on the front end, as it relates to bail, my office policy that we announced, I've been the prosecutor for about 18 months. We recently announced that we are no longer seeking any sort of bail recommendation from the judge for all nonviolent misdemeanor crimes that happen within the city of Columbus. I think that's an important and significant step forward to make sure that we have, as y'all were saying, asking the right question. And if you're committing nonviolent crime, then why are we even going into the analysis of whether you're a threat to society or not? And then on the back end, as it relates to fines and fees, our office general stance is that we don't oppose, and sometimes we even recommend whenever a public defender or even a defense lawyer asks for a reduction or no fines and fees cost, my office policy is we don't oppose those. We don't want poverty to be an indicator of someone lingering and toiling in the criminal justice system. So like on the front and the back end, we're trying to be active and engaged in that space. And then in the things in between, we're piloting different programs. One that we haven't really announced yet, but we're in week 3, and we do it every Wednesday, is a theft diversion pilot program. And the reason why we picked big box theft because I inherited an office whose decade-long policy is that police make the charging decisions. I do not make the charging decisions with the exception of big box theft, so your Walmarts and your Targets. By the way, you can put a footnote there. We're changing that policy. But nevertheless, it takes time to shift there, but it's my goal to change it by the end of the year so that we will bring all charging decisions in-house. So we still have charging decisions as it relates to big box theft. So I've charged my team to think about one simple question that yields a very complex answer. And that is, why did that individual commit a crime? Why did that individual steal from Walmart? Was it because to feed a drug addiction? Was it because of a mental health issue? Was it because of a poverty issue? Was it because the person's a bad person and part of a larger theft ring? Is it all of the above, none of the above? And what we've done is work with a not-for-profit, third-party social group and healthcare organization that will create an individualized plan that deals with not only mental health and drug addiction, but this is where I think we have to go the step further, but treats not only mental health and drug addiction, but looks at food insecurity, housing insecurity, economic insecurity, job opportunity. And then we create an individualized plan for that individual so that if that individual is able to show significant steps of actually going to his or her food pantry in his or her neighborhood, seeking certain job opportunities and showing up with, for example, the Urban League and some of their job training programs, then we, through our diversion program, will dismiss the charges outright. To me, these type of crimes aren't about conviction rates, they're about recidivism rates. And if you truly want to make our community safer, then we have to drive down recidivism rates so that individuals don't continue to commit crime. Because again, if you're fueled by an opioid addiction and you're breaking into your neighbor's car to steal change to feed that addiction, what's to say you're not going to stop doing that in order to feed that addiction? That's the way we have historically viewed the criminal justice system. We have to look at recidivism. We have to treat the underlying reasons why people commit crimes. If we want to give them the hope and opportunity that they deserve, and we truly want to make our community safer, and we want to give them the opportunity as able-bodied individuals to provide for their family. They have to be able to overcome that addiction. It is not enough, in my opinion, when you look at the science and some of the studies that we've done around opioids, simply just to say, go get drug help or drug treatment. You have to provide them with wraparound services, so a holistic approach of the way that we're looking at criminal justice. We also had a failed ballot initiative, and some of y'all in the room may have been familiar with this. It was called Issue 1 in Ohio. It's similar to what Oklahoma did. It downgrade low-level felony possession from a felony to a misdemeanor. It failed in Ohio for a whole host of reasons. It was weaponized in the governor's race. There was some stuff that was politicized around fentanyl, about the good time credit that was in there. But there was some great stuff in issue 1, specifically the downgrade from felony to misdemeanor. And what I did was I ran for prosecutor in 2016. I'm a Democrat. He was a Republican. We ran against each other. I narrowly lost. But every day can't be an election day. And so what we did was, me and this individual who was my former political opponent, we came together and wrote our version of drug sentencing overhaul in the state of Ohio, presented it to the Ohio Senate in a bipartisan way, and it is now the 3rd most important priority bill for the Ohio Senate. It's called Senate Bill 3 if y'all want to look it up. It's a significant step in the right direction. It does downgrade low-level felony drug possession to a misdemeanor. It favors treatment over incarceration, both at conviction, both at sentencing and also for any probation violations. There's some really good stuff in there. There's some stuff that we still want to work on, like retroactivity. But for Ohio, it's an important step in the right direction. And I'm a firm believer that if we can do this stuff in Ohio, if we can do this stuff in the heartland, then we can do it anywhere. If we can ask these questions about why individuals commit crimes, if we can start talking about poverty and the intersection of it in the criminal justice system, we can actually show that we should not have bail recommendations for people that commit nonviolent misdemeanor crimes, then we can be a leader in the heartland that they can drive the conversations for the Alabamas and the Kentuckys and the Indianas, that it doesn't always have to be driven by New York and by San Francisco. Great cities. But when you're in a state like mine, which is a purplish, little bit of red state, like, you can't lead with conversations about how California and New York are doing things. That turns off a lot of folks in the room. But because criminal justice reform is special, and because politics makes strange bedfellows, we are at this interesting moment in time where there's a confluence of Republicans and Democrats and conservatives and liberals that are able to come together, regardless of motives, to actually make a difference in the criminal justice space. And I think that's where we are. And I will end with kind of the last thing that we're venturing out in, and this is something really outside the bounds of what a normal prosecutor would do, is that I've dedicated a full-time employee to work with our local United Way to rebrand and expand our earned income tax credit program. Because my belief is that folks that are interacting with the criminal justice system, if they have free money that's owed to them from the federal government under the IRS tax code, then we need to do our part if we're going to holistically treat people to make sure they have access to that money. To, again, one more thing that we're going to do to help lift them out of poverty so they can avoid the criminal justice system in its entirety. So I'll shut up for now.
Thank you, Zach. So one last question just for the three of you before we open it up to the floor for questions. What are some of the obstacles? What are some of the toughest issues that folks are wrestling with in this space? And what do you see as the obstacles to reform?
I think the biggest obstacle for fines and fees is that we've become addicted to using them as a substitute for taxes. We are at a phase, first we had the tough on crime movement, which got more people involved in the justice system, making it more expensive, leading us to issue more fines and fees. And then that also was followed by the allergy to taxes season, which we still seem to be in. And this is a very easy way for legislators to raise money without really raising red flags and without having people vote in on it. What's happened in California right now, if you get a moving violation in California, if you roll through that stop sign, you think you came to a stop, but not quite. So the police pull you over, you get a ticket. The fine, the underlying fine for that is $100. The added fees that have been added to that ticket are $390. So the ticket you get will be almost $500. We know about half of Americans don't have access to $500 in case of an emergency. That means you're at a starting place where even for average Americans, a simple moving violation that is really not, most people would consider not the end of the world, is already digging you into a system that you can't get out of.
I think in the bail space, it's somewhat different because bail, generally speaking, doesn't generate revenue for jurisdictions, and there's very, very strong arguments that net it's a huge cost because it's not free to keep people in jail who don't need to be there. So we sort of don't have that obstacle, but I do think the more time I've spent in this space that the biggest challenge is is changing judicial sort of mental frameworks about how they even think about this decision. And my thinking about this has changed over the 7 years or so that I've been working in this space, where I used to sort of talk to judges about kind of modifying the way they make their decisions, having more information about risk and you know, more or less tinkering around the edges. I wouldn't have said it that way, but it was kind of the message was like, there isn't a flaw in the way you frame the question, but I actually do think there is, and that what we need to do is have a very difficult conversation about who should be in jail before trial. Money has allowed us to pretend that we don't have to answer that question, because technically everyone who gets a money bail amount is released. Right? It is generally a release order on condition that you pay X thousand dollars. So everyone is being released. It's just, oops, some of them don't have that money, so they aren't actually released. And so the judge never has to decide, and we as a society never had to have the conversation, who are we comfortable keeping in jail before they've been convicted of a crime? That is a tough conversation to have, because there are people who are dangerous, but it implicates some really profound issues to incarcerate someone before they're convicted. And we've allowed money to let us wave that question away and not address it, and now we have to address it head on, and we have to address it through legislation and policy change. But that's a conversation that's unpleasant to have, that doesn't have an easy answer, and those are not the ones that, you know, politicians flock to. So I think that's the big obstacle there.
Zach, obstacles in Columbus.
Yeah, I can say on our Senate Bill 3 work, the biggest opponents that line up and speak out in committee are fellow prosecutors and judges. And it's the organizations like the Ohio Prosecuting Attorneys Association and a group that represents all the common police court judges, which is our felony court, that have been the most vocal opponents of the work that we're trying to do. I will say on the local level and some of the reforms that I've been trying to implement, our local judges are a little bit more receptive. As a matter of fact, in light of our bail announcement, we're actually having a conversation within the next couple of weeks with the administrative judge and some of the other more senior judges on staff about our current bail schedule and whether it makes sense to even have one anymore. So I think being a little bit more proactive on my end has then sparked the political courage and political will for others to maybe join suit. And so we're hopeful that we're going to be able to make headway in that space.
Questions?
Question for Matt. So in my experience, judges are some of the most risk-averse members of the system, and they all either have a case that follows them or afraid of the case that will follow them for life. How do we mitigate the risk of what happened in California, right? That the bail reform went from having a limited cash bail and then having the presumption of release to having a presumption of detention. How do we mitigate the risk for risk-averse judges detaining more people now that they don't have the option of bail?
Yeah, so I mean, what you're referring to is SB 10 in California, which is legislation that passed, and for complicated reasons, it's not being implemented now, pending a ballot initiative. But the idea was, right now under California law, you really can't do what I'm saying you need to do, which is have a yes or no question, and answer a yes or no question about should this person be detained, because under the California Constitution you can only detain a very, very, very small percentage of people. And so California was saying, we're going to get rid of money bail, but in addition we're going to make it possible for judges to actually make that yes no decision that I'm recommending. But they didn't put very tight boundaries around the group of people who are eligible for pretrial detention, and I think it's very risky to do that for the reasons you say. If everyone is eligible technically to be detained, judges have a lot of power to then just do that. And we need to put in place procedural protections and burdens of proof and blah, blah, blah and all that. But ultimately, I think that when we have, largely these are constitutional, but sometimes statutory changes around preventive detention, we need to be very circumscribed about the people who are even eligible. And a lot of the impulse is to say you can be detained if you've committed murder or rape or robbery, blah, 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 like 5 really bad things, or if the prosecutor thinks you might be dangerous, right? And that catch-all provision then swallows everything else. And so anyway, that's a long-winded way of saying I think it's largely going to be decided in legislatures, and that conversation about who should be eligible for detention is the one that we have to have and have not ever had.
As a trial judge, this conversation, I find your comments to be very offensive to a certain extent. I definitely believe there needs to be bail reform. And I think my state's attorney's here, and she knows that if you want to have a bail review, I'm the judge you want to have it in front of. So I'm very, very cognizant of it. But to have a conversation about bail reform and to point at judges and not acknowledge that a bail decision is one of the most difficult decisions a judge has to make. You are basically asking a person to be psychic, to predict future behavior from past behavior, future failure to appears based on past failures to appears. It's a very, very tough decision. Then you have the media that comes into it. And all you need is someone who you put out on bail or let go on his own recognizance, who, God forbid, hurt someone, and for weeks you are the cover of the paper. Now, I know judges are not supposed to think about those things, but we are human, and we have careers, and we have families, and we have futures. And no one wants to be on the cover of the newspaper every day because you let someone out and somebody died because of it. These are very, very hard decisions, and until you've made those decisions, it's offensive to just say that judges are the problem.
Well, I appreciate that comment, and I am very sorry if you heard me, if you interpreted what I was saying as that judges are the problem, because I deeply don't believe that. I mean, judges can't. There are individual judges who are challenging. What I meant to be saying is that we've put judges in the position in a very uncomfortable and unfair position, in that you don't actually. I mean, there are a number of things, but you're not being asked to make the decision that you're describing. You're being asked not only to predict the future, right, which is going to be difficult, and you generally don't have very good data or information, even if you thought you could predict the future based on past actions. But you're asked to then assign a dollar. I mean, I don't know in your jurisdiction. I mean, in most jurisdictions, judges are then asked to guess at a dollar amount, and they don't know whether the person's then going to make that bail or not. And so that's not a problem of the judge. That's a problem of the system that we all have set up, where we have said we're too afraid to have a conversation about who should be in and who should be out, and so we're going to force judges into the awkward position that you're describing, where you have a lot of responsibility on your shoulders, and that headline risk is real. I mean, trust me, I'm well aware of that. But I think the problem is not that judges are bad, and in fact, in the example I used, I was like, the judges didn't even get it wrong in the Khalif Browder and Durst situation. It's that they were using money because that's what they've been told to do, and that doesn't work very well. So again, I didn't mean to suggest that it's the judge's fault. It really is a systemic problem that needs systemic reform.
Yes, ma'am.
I just have a tiny question for Mr. Klein. You mentioned about the charging decision, and you mentioned that in the case of big box thefts, that that charging decision is out of your hands. Is that correct?
It's in my hands.
It's in your hands. Okay. And if it's not that, so was that a result of lobbying by the big box retailers? I mean, I don't understand. To me, a theft is a theft, and if a person steals from the 7-Eleven, it's the police drive that. But if they steal from Walmart, then you then decide whether or not to go forward.
Well, police would still do what we have a U-10, which is an investigative report that they would submit to us, but then we would look at it and determine whether a crime was committed, all the elements were met. And the reason why it's been limited to big box theft historically, and what I've been told, because again I inherited the policy, was because the volume is so high for theft at big box stores that the big box representatives basically historically turn it over to our office to say, you decide whatever you want to do here, we're okay with it. Whereas if you're stealing from someone's lawnmower and you steal someone's lawnmower and you have a real victim, the victim obviously has, we have a Marcy's law. I don't know if other jurisdictions have those or not, but we have a Marcy's law in Ohio. So we have a little bit more consideration of what we have to deal with on the victim side. The victim, in this instance, the big box stores essentially have turned over all authority to us. one thing that we are, as I mentioned, one thing that we are looking to do is bring those charging decisions away from police for all other crimes and have our office review them and make a decision of whether a charge should be met or whether an element, because more work on the front end, but we get rid of a lot of bad cases in the back end because, like, why was this even charged to begin with? Police, whom I love, and they work really hard and have tough jobs. But on my big box theft diversion program, the goal is to expand that to a whole host of crimes. Like you said, theft is theft. But until I get charging decisions, I don't have that ability to make that, expand that theft diversion program until we move those charging decisions in-house.
Yep. No, you're 100% right. I only skipped over that just because of the brevity of the time, but you're 100% right that bondsmen are a very powerful opponent of bail reform, because even though, as I said, states don't make money off of bail, and usually I would argue lose a lot of it because of it, bail bondsmen do make money. And just so you know, the little mom and pop bond stores that are probably in your community are, yes, real mom and pop bond stores, but they're all backed by 7 major insurance companies. So this is big business. And mom and pop don't have $200,000 to lobby at the state capitol, but you can bet that the parent insurer does, and so that's what they're doing. So, so you're right. Bondsmen are a big obstacle, but I think that there are folks in this room who've worked on this issue and getting data to show jurisdictions that the bondsman's arguments are really specious and that the current system actually doesn't protect public safety. It's very unfair and it costs a lot of money. That can help win the war, but it is no guarantee because it is, you're right, it's a very powerful lobby.
And I will say, the moment I made my bail announcement, my phone blew up with all the bail bondsmen that wanted to have meetings with me. So it's real.
Please join me in thanking our panel. And as a final thought, I just wanted to say thanks to all of you for being here, for participating in this conference over these 2 days. Obviously, you're all working day in and day out in the system, trying to arrive at the most just outcomes. So we really appreciate your thoughtfulness and your attention to these issues. Thanks so much.